Hi everyone, my name's Matt Hudson. I'm one of the partners here at SV Partners, and I'm joined today by Michael McDonnell, who's a partner at Results Legal. Mike's been good enough to join me here today because we're going to talk about all things shareholder and business disputes. So we've got quite a few things we want to go through, but as always, those who are listening in, tuning in, please feel free to comment. If you can like the video as well, share it. We'd be very grateful. The other thing I would say is that at any time after the presentation, that Mike or I can certainly field any other questions. We can more than happy to assist with anything you might have. Mike and I think we probably met about 8 or 9 years ago now, roughly, and he's been a lawyer on many or a number of my matters and has done an amazing job. And one of the key things that we've certainly noticed over the last few years is the substantial increase in these shareholder disputes. I've got a couple of matters at the moment that are through that just and equitable wind-up space, where effectively the principle is you've got two, for a lack of a better word, warring shareholders, and because they can't see eye to eye, a liquidator needs to be appointed to try to sort out the affairs and wind up. So we're going to go through a few things today, and one of the amazing things that Mike's been able to show for us, which I'm going to put up on a screen in a second, is a series of statistics as to shareholders' agreements, or the lack of them, I should say, and some other things that we're going to go through. The second part is we're going to go through some legal principles from some key cases, and then finally we're going to have some takeaways. So I'll just going to put up the slides now, and hopefully everyone can see those, and I'll let Mike start going through some of these key lessons that he's been able to get from his experience.
Thanks, Matt. Honoured to be here, and thanks for the opportunity. Hello, everyone. The topic's important because disputes are an inevitable part of business life. It's a timely topic, as Matt mentioned, because there's a lot of these disputes on at the moment. There's an overlay with the insolvency laws in terms of appointments on just and equitable grounds for solvent companies. There's an overlay with the appointment of receivers or trustees and all the rest of it more generally with the oppression grounds and other remedies that are often exercised. And it's also relevant to us as professionals because it's incumbent upon us to identify commercial risks and opportunities. As Matt mentioned, we're going to cover off some of the lessons we've learned from running these cases over the last 20 years. We compiled a survey of over 100 of the matters. We've done that to identify and distill the recurring legal issues, but just as importantly, the recurring commercial issues, so that we can see the themes that arise, and it confirms what we see day to day. And then we're also going to have a look then at the end just around the ethical considerations for us as professionals. That's very important, so don't log off until we cover that off at the end. You might be surprised. So there's one recurring issue in all of these disputes, and that is value and price. Now, as we know, value doesn't equal price, but what we're talking about here in terms of business separation is the price that a seller will accept or be forced to accept to sell and exit. That could happen by way of a direct sale to somebody else or in terms of a share buyback from the company. And it can happen in two broad scenarios. One, by negotiated transaction in each case, customised negotiation. That's not recommended, or it can happen automatically and be fixed to occur under a shareholders agreement, and that's highly recommended. So, as you know, there's many ways to value a business. It could be equity, enterprise value, market value, enterprise value. There's fertile grounds for dispute. We can have disputes around the multiple valuation date. We litigate often around whether there should be a minority discount or a discount for the lack of control, for the lack of marketability, whether there should be a premium that applies as well in certain cases. And as I see it, as accountants and lawyers, this is a big opportunity for us, and we're best placed to assist our clients to formulate a fair, robust, and current valuation clause.
And I think that's where, and what Mike's going to talk to is having this strong, having this shareholders agreement in place that can actually deal with these types of valuation clauses is going to be far easier and I guess cheaper than having to go out externally and get an independent valuation if there's not something that's already been agreed to. So I'll let Mike speak to the
Absolutely.
to the slide here.
So, of the matters that we surveyed, 36% didn't have a relationship agreement in place. And as we've noted there, people need to avoid being penny wise and pound foolish because, as we know, the scope and the breadth of a dispute will be far, far deeper and far broader. There'll be a lot of additional costs, there'll be sunk costs, and there'll be massive impact if we don't have a decent agreement in place.
I think if I could just add to this 36%, I'm just thinking back to the jobs that we've done as insolvency practitioners. I reckon that figure is probably closer to 99% have never had a shareholders agreement, and you could certainly see where they may end up into trouble and why they may be in liquidation. So it's probably not surprising that there is such a low percentage, such a high percentage that don't have it. Yeah.
Spot on. And then, if people run a business in partnership with others, there's more than one shareholder, they should just have one in place. It's the best risk mitigation they can invest in. There are a few key provisions as I see it that we've identified looking through the data. Firstly, there should be a clear and easy to follow process governing the transfer of shares within the existing shareholders. In other words, preemptive rights. There should be restrictions on sale. Secondly, as we're talking about with the recurring issue, there should be a process and methodology and/or process to value the price of the shares, and the valuation methodology should be current and fit for purpose. By that I mean it should meet the requirements of the business now, not what they were 10 or 15 or 20 years ago. Constitutions do not usually have effective valuation clauses in place, neither do boilerplate off the shelf shareholders agreements. They need to be custom jobs. What we do is we work with our clients' accountants to formulate something that's fair and something that is robust. So when you need to call upon it, it's fair for everybody, and you don't need to go and spend a lot of money having to go and get specific performance or litigating about that. The other thing is how I describe it is it should be an easy in, easy out model. It should apply when you're raising further capital or issuing further rights to existing shareholders or incoming shareholders, and it should apply if somebody's a seller. So if somebody wants to sell, that price should apply. We can wire in the third point, we can wire in discounts for bad leavers as well, and all of those sorts of things. And what we often see running these cases where there's a bad leaver, there could be fraud on the part of a shareholder. Sometimes these processes to exit a bad leaver aren't effective, and they're not self-executing in the sense that we need to run through a process that we can't compel a sale, and that's very costly. And then we go back to that point of having to have a specific negotiated outcome each time, which is good for litigation lawyers and liquidators because it increases the likelihood of an appointment, but it's not in the interest of business. Second and fourthly, there should be a buy-sell procedure or agreement in place that applies in a sad leaver circumstance where there's a death of a shareholder or a key person. It should be backed with insurance, or where there's a TPD event. I know that lots of businesses who have had to call on that in the past, including unfortunate SB, it's good to have their comfort for everyone involved. And fifthly, there should be restraints and restrictions post departure for reasons that pretty much go without saying to this audience.
Yeah, I think from what I've seen on bad leaver clauses and all that type of stuff, it certainly does help that you can try to particularize that as well as you can. I think having that discount in there is certainly very important. Would you say that people should be looking to get these agreements reviewed every few years?
Spot on.
Yeah. So I reckon every few years you should certainly be reaching out to your lawyer again, making sure that it's fit for purpose and cutting edge. So
Spot on.
Yeah.
Yep. And if you're an accountant, you should have it in your client meeting checklist to ask them, your clients, about whether they should have one and whether they have an agreement in place and whether it's been reviewed recently. Accountants are really good at asking about estate planning things and those sorts of documents, but these are very important, in my view, more important at a company and group level, leaving aside the question of the people behind the business. Then of the 64% that had shareholders agreements, to go to your point, Matt, less than 30% had what you describe as a good agreement with the key provisions in it. So what we know is that only 1 in 5 have effective agreements in place, and that what we also know is 80% of those people that walk into our boardroom or we speak to initially, it's going to cost more. There's a higher risk of an external appointment, and there's going to be more stress with it all. So people should be getting decent agreements in place, getting them avoided. And whilst we've got nothing against liquidators, they perform a very important role in society. It's not
incredibly important role.
It's not in the interest of business generally, where disputes can be avoided with smart drafting and spending time up front, negotiating. There are some other themes here on this slide when it comes up. 30% of their businesses were professional services businesses, a lot of them accounting firms, which begs the question, who said accountants don't like conflict? Well, maybe they don't, which is why there was conflict. And then we also ran a lot of minority shareholder cases where we acted for minority shareholders to assist them to get a fair outcome or a fair price on exit. A lot of the issues our clients faced in that scenario were being oppressed within the meaning of the Corporations Act 232 and 233, with unfair dilutions, being the subject of rights issues, being the subject or being forced out of the business, those sorts of things. And what my take on this is that over the last 20 years, running these cases and speaking to people in business and other professionals, they might be accountants or earlier lawyers or referring lawyers, people labour under the misapprehension that minority shareholders need to take what they can get, which is usually below fair value, and that they don't have good grounds and good rights to exercise to get paid fair value. And that's something we see time and time again.
Yep.
To give an example, we ran a matter where we consulted with some clients who had, shortly before we were engaged, received an offer to sell, or to be bought out rather, but them selling. And it looked pretty good. It was from a well-known law firm, was backed by valuations, had the usual vitriol attached to it that they were going to do all sorts of things. And this was the last offer. And we ended up getting an outcome that was 7 times better for them once we were involved. We worked with forensic accountants and we commenced litigation and did all those sorts of things. So your clients should not just take the first offer that they're given. They should engage in a process to make sure that the very important decision they're going to make means that they get fair value and they're not going to be the subject of further unfairness.
Yeah, well, you got to love the when they threaten the last offer and stuff like that.
Absolutely. Another one that comes on there as well, Matt, that the audience might be interested in is that intra-family disputes. So we come across a lot of these, frankly, and what we're talking about here are families that are in business together. We're not talking about family law property settlement matters or disputes between spouses. We're talking about disputes between parents and their siblings, cousins, or parents and their children rather, siblings, cousins, those sorts of things about trading businesses. No one will be surprised with the issues that we identified around lack of formality, around unfairness or prejudicial treatment, unequal inputs, and lack of involvement in the business, family dynamics, lack of cohesion, inadequate business succession as well. The old golden child syndrome sits all within there as well. But what we, in our view here, these families who are acting proactively are having hard discussions. They're adopting what's referred to as family constitutions or family agreements, or as some people refer to them as living wills. And where you do that and have that in place, it sets the family up for success, sets the clarity in terms of expectations, how many hours they're supposed to be in the business, how much leave, who takes what motor vehicles, what children or grandchildren or great grandchildren can come in the business, what their inputs are and expectations, and really sets up the business for success so that once the matriarch or patriarch dies, it sets up for that long-term business succession. Having the discussions up front, which is really good, the ones that we've seen that work. But the overall takeaway with family business disputes is that, and people in business generally with their family, they need to be more formal and business-like, and because in reality there's too much at stake not to be.
Yeah, and I think one of the previous slides you showed, there was a particular statistic on farmers, and
Yep.
uh, there's obviously going to be a lot of family dynamics inside of those arrangements, and I can just see um, where these types of issues could certainly pop up when it comes to agribusiness and that. So I agree. I think it's very important to be on top of this straight away. What we will now do is start talking about some cardinal rules. There are 5 of them that results have put together here. And I'm just getting the slides to move for everyone.
Absolutely. And what we're looking at here, we could spend hours talking about this, but we want to safeguard the client's interests and identify avenues to achieve fair value on an exit, even in the face of a deadlock or a dispute. And broadly speaking, number one, if that's going through, if you're a director, don't resign. Control is power in commercial disputes, as it is in life generally. Directors have an entitlement to books, records, information, entitlement to attend meetings, get information from third parties, including banks and the like, and consult with staff. We often consult with people who inform us that they've resigned out of frustration because they haven't been able to negotiate an exit. And they say, well, look, that'll teach them right, I've resigned.
Yeah.
It's not a good thing. Don't give up these significant benefits. They're hard to get back. So it's something that might go without saying to the audience here, but not necessarily with your clients.
Yeah, and also, especially, don't just text message the other directors screaming at them basically and saying I resign. It just
Spot on.
Yeah, not a smart strategy at all.
And if you just go back to the
Yeah,
prior slide there, Matt, and secondly, people need to not should avoid starting a competitive business or breach shareholders' agreements, legal obligations and duties such as misusing confidential information and the like. We also regularly see people come in and they say, look, I've tried to negotiate an outcome. I'm the key person in the business. They won't buy me out for fair value. So I've just gone down the road, opened up a new shop in competition. I'm taking all the clients, and plus I've got all the information in my head and I've got some printed out, so that'll be okay. Not a good idea, because as we know, the principles there are arising from the law of partnership that the profits of new co in most cases need to go back to old co there until the separation's been negotiated. There's also restrictions on the use or misuse of confidential information that subsists at law. Plus, there's also issues with being found to be held in default and breaching the shareholders' agreement, which will give rise to, if it's well drafted, bad leaver, exits, discounts, all of those sorts of things. And as we all know, in the modern age of business, IT audits and email audits are telling. People need to be careful what they're doing in that sense, and they need to not walk themselves down a path of no return and end up on the back foot.
It's probably also a breach of director's duties if you
Spot
do
on.
some of that stuff if you are a director, and and also probably your fiduciaries. So
Absolutely.
it won't just be about your shareholder agreement. So you need to think a bit more broadly and get that expert advice first before you go gun ho. And yeah,
Spot on. And people taking the ostrich approach, doing nothing and hoping things will get better, as we all know, they won't. It's not a good strategy. Delay equals danger. And it also gives rise to arguments about waiver, acquiescence, abandonment, all of those sorts of things. People need to take appropriate advice. If they don't do so, it'll prejudice likely an ability to exercise their strict rights. And fourthly, this is one of my favourite ones, don't exclude or lock out another director or shareholder virtually or physically. The olden days, the locksmiths used to make a handsome living out of locking out business partners from premises, but now that seems to be done via the keyboard by IT consultants. In either case, that shouldn't happen because that will likely be found to be oppressive. So people need to be careful. And fourthly, or fifthly rather, people shouldn't be issuing any default notices or alleging breaches of duty and those sorts of things unless they take, as Matt said, legal advice and expert advice, accounting advice, because it can end up putting them down a path of no return. And they need to have a strategy in place. And I should just add one final thing on that point, and it could be even a sixth point, but where the dispute is essentially between the shareholders, the people need to ensure that the company takes a partisan or neutral position, or doesn't take a partisan position, I beg your pardon, and isn't seen to be favouring any of the shareholders, including by providing funding, loan account on a loan account even, or doing anything that could end up being found to actively assist by way of participating in the dispute. So that's something that need to be mindful of as well.
We'll start with this.
Absolutely. So the Vigliarone principle. So the prevalence and use of trusts in business nowadays is very high. There's obviously a lot of insolvency law around it. It's topical at a policy level at the moment as well. Wanted to share this case with you. It was a single judge decision in the Victorian Supreme Court that ordered the buyout of the shares in a company that acted as trustee of a trust, and also ordered the buyout of the units in a unit trust of which the company was trustee. It hasn't really been applied in New South Wales, but it hasn't been tested on appeal yet. But it is something that we use as authority for the proposition that it applies with unit trusts. Question is if it goes any further with discretionary trusts. Obviously, a discretionary trust, a beneficiary doesn't have a fixed interest. Whether that's going to go somewhere like Rich Star number 6 when Justice French was in the federal court before he became the Chief Justice of Australia. That's probably a bit too far. That case that arose from West Point, but it's something to look at down the track, whether it can go further to remove and appoint or relinquish rights and those sorts of things.
I don't know about discretionary. I think that's
too far.
It's a bit far. I think my LinkedIn, I would be definitely doing a post on that if it ever goes discretionary.
Excellent. There's a well-recognised instance of oppression where a shareholder has an expectation referred to as a legitimate expectation of participating in management. This applies in closely held companies or quasi-partnerships. To be very clear, these partnership principles apply by analogy. It's not saying that the company was a partnership at all. It's just by analogy, these principles. So that arose from a UK decision of O'Neill and Phillips we've mentioned there in the slides. In essence, if there's an understanding that a shareholder should participate in the management and they've been excluded, then that will be found to be oppressive, and that will likely give rise to rights to seek relief under the oppression provisions. People should be aware, as we've noted there, that NASA versus Innovative Precasters Group, that if the removal from management is accompanied by a fair offer to buy out the person removed or the shareholder removed, that won't in itself always be oppressive. And the case we look at in Australia is the William Buck decision there in the West Australian Supreme Court that looks at 5 factors to consider whether an offer is fair and reasonable, and a couple of them, one, whether there shouldn't be any discount for the minority holding. There needs to be a determination by an expert. There needs to be the provision of information or not freezing out the person with the right to access information. And there also needs to be an offer of legal costs being paid as well if costs have been incurred in those circumstances, which feeds on nicely to the next point, that is where we prove oppression, which is why we always go to oppression grounds divorce, the at-fault divorce, as opposed to the just and equitable grounds winding up that we seek in the alternative, or the no-fault winding up or no-fault divorce, as Matt referred to earlier, is because the general rule is that where we prove oppression, there should not be a discount where the shareholding being sold is a minority holding. And as we all know, the general principle is there should be a discount where the shareholding is less than a controlling interest for the lack of control, the lack of marketability, and the like. So there's some cases there. Short and Crawley's one worth having a look at. But the principle is that where somebody or where the oppressors have dealt unfairly with the oppressed minority, they should not be rewarded or benefit from their breaches and bad behaviour. Sort of pass the pub test in my view. So, they can't have a win at the expense of the oppressed, in essence. Here's another one. It's a decision from the Victorian Supreme Court in March last year where the oppressor majority had a big loss. The case, for those who have read it, well done. It's 480 pages long.
Even I didn't. I haven't read it all.
There were 15 other judgments in the matter, including a matter in the High Court. Interesting case, 52-day trial. But in essence, what happened was the oppressed minority sought, by way of relief, an option to buy out the majority. That's never happened in Australia before. It has in Singapore and has in the UK in cases I've followed over there. But what ended up happening...
It's a crazy concept to think of that a court would rule that a minority shareholder group can buy out a majority. Is
spot on.
I can't think of any time I've seen that in any cases. Yeah,
spot on. And as the judge has noted here, he felt that it's appropriate where such an order would relieve the oppression and deny the oppressors the fruit of their oppressive conduct. So in other words, the age-old understanding that people could just oppress someone and cure it with money by way of being able to and have the benefit of buying them out, that no longer applies. There's a paradigm shift, and I can't wait to get some of these orders myself.
Yeah, love it.
I think this is the final one now, but something to keep in mind. And at the starting point here really is that where oppression's proven, a winding up order on oppression grounds or 4611A on just an equitable grounds is the starting point. And the reason I say that, click the next one, please, Matt, is that there's case law that goes and looks at the capacity and willingness of a defendant who is ordered by way of a compulsory buyout order. There needs to be evidence of their financial capacity to comply with the order, or as a judge in Sydney put it, I'm not going to order somebody to do something to cure the oppression if they can't do it. And we rarely see people in these cases, the defendants or the company, in terms of a buyback, providing evidence of their financial capacity. So it's something to be aware of. The Queensland Court of Appeal decision in Sangris or Asia Pacific Joint Mining, there notes and things there. That was an appeal in relation to whether the company was wound up by Justice Bond at first instance. There was an appeal about whether a buyout order should have been ordered, and it was 3-zip, the appeal. And what they said was, in essence, there was no evidence of the capacity or willingness to meet a buyout order. And there were also difficulties in that case around valuing the mining tenements as well, which is something else that people need to keep in mind.
Probably the only thing I'd add to it is that the winding up is always seen as the last resort under one of these types of applications. So the relevant section is 4611K of the Corps Act, and every case I've read, it's pretty well the court tries its best to find a solution or a relief. But if it's just not possible, then and your company could still even be solvent when that wind up occurs. I've seen a few of those over the years. So it doesn't even matter if it's insolvent or not.
Absolutely. And if those interested, Justice Jackson wrote the third judgment in there and refers to a lot of what Justice McPherson wrote about in Dalkeith investments in the 1980s. Justice McMurdo wrote a really good judgment as well. It's worth going and having a look at those things. And that's been picked up in New South Wales cases subsequently as well, on the point that we had a matter that traversed those in detail recently.
If you don't want to have to actually read the case, there is a website you can go to called Fee Firm, and it'll give you a quick summary on the case. It's a quick plug.
There you go. Finally, ethical considerations. So, as trusted advisors, you guys have a unique opportunity, in my view, of obligation to assist your clients in relation to these matters. What I wanted to share with you is something that I think is really, really important. That is to be mindful of our own ethical obligations in these cases, as with practice generally. On the screen there is a decision from the Chartered Accountants ANZ Disciplinary Tribunal from a couple of years ago involving a chartered accountant, Mr. Kenneth White, from 2020. In essence, Mr. White acted as an accountant for two family groups in business together. They wanted to do a business separation, and Mr. White assisted them when in relation to a transaction or separation. He didn't refer them on to independent accountants. He didn't refer them on to independent lawyers. And what they found, the disciplinary tribunal, in the 34-page judgment, is that he failed to comply with his obligations to avoid conflicts of interest, his obligations of objectivity, and he failed to comply with APES 110. And he was fined 33 grand. He was censured. He had to undertake a review and training, and we're talking about it today. This is not uncommon in my view. We've sued accountants in the past who have acted to prepare separation agreements in these scenarios that have been lame, that have given rise to perverse outcomes, including tax outcomes. So be very careful, because if your client's saying, oh, you just help, you can do it all, you can't. You need to comply with your ethical obligations, put your own interests first here, whether you're a lawyer or an accountant or other business professional, and you need to refer them on to get independent financial and accounting advice. Otherwise, you could render yourself liable to criticism and complaint, and also potential litigation. I'd much prefer to get a referral from a professional rather than asking to act for them in disciplinary proceedings or litigation.
Yeah, well, Mike actually sent me this case probably end of last year or something like that. I couldn't believe some of the things that I read in there, and the obvious conflicts and other things. So, yeah, great case to read. Unfortunately, that case won't show up on the FIFO firm. So,
You might be able to make it available.
yeah,
Yep.
yeah. Well, I can. It actually says on the slide, click here. So, after this presentation, I can add that link onto the comments to help people.
Absolutely. There's a bit of a summary here. As professionals, we just need to ensure that our clients have got these agreements in place. If they do, have them reviewed to ensure they're fit for purpose and relevant and meet business needs. We need to ensure that our clients have got valuation methodologies in place, and we need to avoid conflicts, and we can render valuable fees for assisting them if we refer them down the road.
All right. Well, I think we'll wrap it up and get into some key takeaways for those listening. Yeah, if you want to take it away.
Absolutely. As I just mentioned, getting those agreements in place is important. Pro tip, as we noted earlier, is to, with your client meetings, have a checklist there as a prompt to ask the question about whether they, circumstances, they should have an agreement in place, a relationship agreement, shareholders agreement, partnership agreement, JV agreement, unit holders agreement, whatever it is, or they should have one in place that regulates their business relationship. It should be reviewed regularly, and if your clients are encountering or may have an issue in terms of business separation, or there's a war between certain shareholders, they should get independent accounting and financial advice, but also independent legal advice. And the company needs to have its own independent lawyers, because otherwise it may be found to be acting as the stalking horse for some group of shareholders. And it's just very important not to give grounds to an experienced litigator to make out oppression to meet their clients' expectations at the expense of the company and other shareholders generally.
And also to protect your legal professional privilege, having that independent lawyer. Realistically, probably the shareholders each should have their own independent lawyers. If it does get into that dispute level, it's something that we've been talking about, particularly internally around safe harbour. And if someone comes to me and says, "Oh, can you do up the safe harbour agreement or something like that?" my view is that they should personally engage a lawyer, and then the lawyer can engage us so that we can maintain that legal professional privilege. So,
Spot on. Yep.
great. Well, I think that's probably it from us today. We're pretty well right smack on time for our normal. So we did cover quite a bit there. So what I'd say is, if you do have any questions or comments, please feel free to leave them in the bottom of the video, or just send
Just
a
reach
private
out. Yeah.
send a private message. I'll put Mike's details in the comment box as well. So feel free to email or call through to the firm, and yeah, we can go from there. Otherwise, you can leave a comment, and I will certainly see it and I can pass it on. So, but thank you so much,
Thanks,
Mike,
mate.
for being here, and we will have another LinkedIn Live going, I think, in 2 weeks' time. We're going to be talking about construction law and how that relates at the moment with the different things going on with insolvency and various collapses. So stay tuned for that. But from tomorrow, I'll go back to just posting normal updates on my LinkedIn. So feel free also to check that out. But I thank everyone for tuning in, and thank you, Mike.
Good afternoon.
Thanks, everyone.